Appeal routes in civil cases. While the specifics of the appellate courts are laid above, it is likely to be useful to provide a list of the usual appellate routes from both the county court and the high court. Appeals from the county court. From May 2000, the avenues of appeal from the county court have been set out in Part 52 of the Rules of Civil Procedure. It means that in general, for fast-track cases dealt with by a district judge, the appeal is heard by a circuit judge. For fast-track cases dealt with by a circuit judge, the appeal is heard by a high court judge. For final decisions in multi-track cases heard in the county court, whether by a circuit judge or by a district judge, the right of appeal is to the Court of Appeal. Appeals from small claims. In October 2000, lawsuits of rulings on civil charges were made feasible. This presumption to appeal was adopted in order to conform with Article 6, Presumption to a Reasonable Trial, of the European Convention on Human Rights. The appellate paths are the same as the fast-track proceedings. It implies that the challenge is to the next court of the process, and if the matter has been heard before the district judge, the challenge is to the circuit judge. Whether the dispute has been dealt with by the circuit judge, the appeal is to the Supreme Court judge. Second appeals. If the first appeal is considered by a district judge or a Supreme Court judge, a second petition can be filed in the Court of Appeal. Nevertheless, that can only happen under extraordinary circumstances, as specified under Section 55 of the Access to Justice Act 1999. No appeal may be made to the Court of Appeal, unless the Court of Appeal considers that a. The appeal would raise an important point of principle or practice, or b. There is some other compelling reason for the Court of Appeal to hear it. Appeals from the High Court. From a decision in the High Court, the appeal usually goes to the Court of Appeal, Civil Division. In certain instances, a leapfrog appeal can be taken directly to the Supreme Court under the Administration of Justice Act 1969. Such an appeal must include a question of law of general public interest, which is either dealing with the application of a rule or which includes a legal precedent of the Court of Appeal or of the Supreme Court/House of Lords where the judge of the case will observe. In fact, the Supreme Court must grant leave to appeal. Further appeals. A further appeal is rendered to the Supreme Court through the judgment of the Court of Appeal, but only if the Supreme Court or the Court of Appeal grants permission to appeal. It can also be remembered that the matter can be appealed to the European Court of Justice according to Article 267 of the Treaties on the Operation of the European Union if a question of European law is concerned. Any other request can be provided by an English judge.